Participants are recommended to stay connected throughout the session to achieve at least 75% attendance and submit the post-assessment form at the end of the session to qualify for the participation certificate. All the participants are now requested to fill out the pre-assessment form to be eligible for the certificate. Please scan the QR code displayed on the screen to access and submit the form. And all the participants are kindly requested to please switch on their cameras and please ensure that your audio is muted. A very warm welcome to one and all present here. To introduce tonight's theme, consider this thought. Privacy is not just a legal obligation, it's the new currency of trust in the digital economy. And today's topic captures this reality beyond compliance, making privacy a business advantage. And I'm Manita Singh, and with me I have Divya as my co-anchor, and it's our privilege to anchor today's session. This lecture is part of our Cyber Sunday series, episode 27, initiative designed to promote awareness, learning, and informed engagement in the field of cyber safety, law, and technology. Through Cyber Sundays, we bring together legal experts, policymakers, industry practitioners to share actionable insights on the most pressing issues in cybersecurity and data protection. If you're ready to start this journey, please type ready or show your enthusiasm through a thumbs up emoji in the chat. It now gives me a great pleasure to our distinguished guest lecturer for today's session, Ms. Akanksha Bhatt. Ms. Bhatt is a partner at G. Giri and Partners LLP and led data privacy consulting at Consently Consulting, a brand of G. Giri and Partners LLP. She is an advocate and data privacy and DPDPA compliance specialist with over 7 years of experience in end-to-end GDPR and Digital Personal Data Protection Act implementation across financial services, healthcare, automotive, e-commerce, retail, and manufacturing sectors. She has led enterprise-wide privacy governance frameworks, established data protection officer functions, and advised C-suite leadership on privacy transformation strategies for major corporations. Her expertise spans from DPDPA, GDPR gap assessments, DPA SEC drafting and negotiation, DPIA execution, cross-border data transfer compliance, and privacy by design implementation. She has negotiated complex contracts and DPAs, delivered organization-wide privacy training programs, and is a certified ISO 27701 Privacy Information Management System lead auditor. She holds an LLM in Maritime Law from Gujarat Maritime University and a BBLLB from IMS Unison University. Please join me in extending a very warm welcome to Ms. Akanksha Bhatt. And
Thanks.
without further ado, I would like to invite Ms. Akanksha Bhatt to please take over the session.
Thank you. Will you be sharing your screen with the PPT that I have shared? Okay, thank you. Hi, everyone. Thank you so much for joining today's session. As the headline and the topic suggest, I always say that, privacy is not a business deterrent. It's a business enabler for most of the organization. Now that we also have a Digital Personal Data Protection Act enforced in India, we just want to ensure that every business is compliant with privacy whenever they are thinking about engaging with personal data in any manner. So, of course, DPDPA only covers the digital personal data, but we also want to ensure that all personal data that we collect manually, which any organization later going to digitalize, that also somewhat comes under the purview of this act. So that should also be secured. And the major scope and intent of this legislation, I mean, why all of a sudden government thought that we should have this particular legislation, is of course the roots go back in 2013 when we had the Puttu Swami judgment in place, where the right to privacy finally became the fundamental right in India. Apart from that, if you read the DPDPA, the scope and intent specifically talks about how how the act provides more power to the individuals, the citizens of this country, regarding their privacy rights, and how in no way this act, this legislation is going to stop such organization who collects personal data for the collection of it or for using of that particular personal data. Instead, it's going to provide more transparency to the users, so they're aware how these organizations are using their personal data. Just think of it like this: before the DPDPA was in picture, you as a user had no rights over your personal data, right? You couldn't go to any organization and tell them that I don't want to give you my mobile number. I mean, this is something that we have been doing. People say that in India we give our data like candies, and organizations have been showing them for a long time now. So DPDPA and the privacy principles that we have today are there in place to protect all of these principles that we have, all the rights that we have in DPDPA. So the agenda of this session, I have kept it semi-legal and also somewhat techno-legal, where initially we will just be discussing about what DPDPA is all about, and how we can implement DPDPA within the organization, how you can become privacy experts in your fields, and what this law brings. Vanita, can we go to the second slide? I'm sorry, I'm not able to see the second slide. Yes, we can go to the third one. I already covered this. So this is what we'll be covering today. Now, when you think about privacy, I would like all of you to drop one sentence, or one word. What do you think of privacy compliance? That could mean to any organization. Of course, our audience is more students. So just think of privacy compliance as a word and see how you can implement it in your words, and what do you think a compliant organization would mean. We can move to the next one. So let's understand about DPDPA awareness. Who would be the stakeholders? What the real law is? So Digital Personal Data Protection Act was enacted on 11 August 2023. Now, before that, it obviously started with the Puttaswamy judgment in 2013, where the right to privacy became the fundamental right. Post that, we had the JS Krishnan committee report, where most of the recommendations were given how this act should look like. Before this act became a legislation, there were multiple bills presented in the Parliament of India. One of them was known as Personal Data Protection Bill. So, mere the name of this act had to go through multiple changes before it actually came into picture or existence. Finally, on August 11, 2023, both the houses of parliament gave their assent to this particular legislation, and it became a law. Post it became a law, there was still a duration of time where organizations were unclear whether this will be presented as a legislation, whether this will go forward. But finally, on 5th November 2025, we received the set of rules which will go with this legislation, which are called Digital Personal Data Protection Act rules. Now, we have the legislation in picture, we have the particular rules as well. There are certain key stakeholders in this act if we talk about. The first being data fiduciary. So, who is a data fiduciary? Any organization who collects and processes personal data on a daily basis for their own services, for operationalizing their services, they will be known as data fiduciary. Think of it. Think of it like an example. All of you might have a bank account. So when you go to a bank and you share your personal data with that particular bank, and the purpose is account opening. So the law says any organization who collects personal data and who also determines the purpose of collecting that personal data, they become data fiduciary under the act. The second major key stakeholder that we have is data principal. Now, who is a data principal? All of you, if you go to colleges, then you are acting as a data principal for your colleges. Any bank account holder, if you go on any website and they collect your cookies, you automatically becomes a data principal. your teachers, they all are data principals to your colleges, because your college at the end decides the purpose and means of collecting that personal data, which makes them data fiduciary. You is someone whose data they're collecting. The data belongs to you, all the personal data that you collect. So you all become data principal under the act. Then we have the third major stakeholder, which is called data processor. So who is a data processor? For example, you have a college and your college also hires certain placement agency. Now your college shares your personal data and your resumes for placement with that particular placement agency. You have a relationship with your college as a student, but you do not have a relationship with that particular party, that placement agency where your data is being shared. But at the end, they are helping your college in providing certain services, right? So any third party where the data fiduciary shares their personal data to help them with that particular services. You might have seen that there are certain cloud hosting platforms like AWS. So AWS acts as a data processor for most of the organization, where these organizations are storing their personal data. Mintra as a website, they tie up with a lot of delivery vendors like DTDC or DHL. So they all are Mintra's data processors, because a data processor at the end acts on behalf of the data fiduciary, where the data fiduciary only decides the purpose of collection of that personal data, but the data processor eventually helps them and also stores and collects personal data of the data fiduciary's customer, or of the data fiduciary's data principal. So they eventually become data processors. Any third party that your college use, or banks usually don't have an internal call center, they have an external call center where they reach out to their customer. So in this scenario, banks share their personal data, their customers personal data, with a third party, which is a call center, which is another organization. So that particular call center will act as a data processor for that bank. So any party who helps organization in providing these services smoothly, they all act as data processors. So now that we have understood who is a data fiduciary, who is a data principal, and who acts as a data processor, let's also talk about the key provisions that we have in the DPDPA. The very first being is DPDPA applies to the digital personal data, which means any organization who collects personal data in digital form, or any organization who collects personal data manually but later have plans to digitalize it. For example, if they collect your data on paper and later on they are going to scan it and put in their system, that eventually becomes a digital personal data. In most of the scenarios, you go to an event and they just collect your name and mobile number for feedback on the feedback forms. But what they do with it, they feed that particular data into their system. So that becomes digital personal data. That is one thing. Second, when it comes to the territory of this law, how it applies, where it applies to any organization who collects and process Indian citizens' personal data. That is first scenario. Second, what we have under the law is that any organization, whether they are based in India or outside of India, but they all targets Indian citizens, they all collects and process Indian citizens personal data, it applies to such organization as well. Before DPDPA came into picture, we also had certain other laws like the General Data Protection Regulation, which is the GDPR of EU. So wherever any organization who is based in European Union, or any organization who targets European Union customers or citizens, GDPR is applicable to them. So DPDPA and any other data protection law that you see now, for example, UAE have their own data protection law, which is called Personal Data Protection Law (PDPL). That is also somewhat based on the GDPR principles. So GDPR is also known as the father of all data protection laws in the world. Whether you talk about Canadian personal data law, South Korea personal data law, and then of course DPDPA being in the picture. So apart from these things, of course, the law applies to any Indian citizens' personal data, and any other organization who don't have offices in India but still targets Indian citizen. The law applies to them. Now, as a data principal, you also have certain duties under the act. Like when you share your personal data with data fiduciary, what you should be considering, but we will discuss that later. First, let's understand as an organization what obligations do you have. For example, if your bank collects your personal data prior to the enactment of this law, they could collect whatever data they want without even thinking about it, without even giving you a choice to say yes or no. But the DPDPA focuses more on the consent aspect of it, where consent is the core of this legislation, which means now you as a student, you as a account holder of any bank, you as any party who go on any of the websites or attend any of the events where they collect your personal data have certain rights, and that party who collects your personal data have certain obligations to follow. The first one being grounds of processing personal data, which is section 4. So the law says that as an organization, now you have two grounds to process personal data. And these are called the lawful grounds for a reason, because now only under these two lawful grounds an organization can collect your personal data. Section 4 says the first ground is consent, which we will discuss in detail because consent actually covers most part of this particular act. And then we have legitimate use, which comes under section 7. We will discuss that later as well. Let's start with the consent. So when you think about consent, also think of the contract law that we have in picture. So here also we are somewhat applying the same principles. The law says your consent should be obtained free, it should be informed, unambiguous, a very clear consent. Now how it can be how it can be obtained freely, right? How it can be how they can inform you about the consent, and how it should be specific to the purpose. So let's take an example of a bank again. You go to a bank website and you just want to apply for a personal loan. So the first time you add your mobile number and then OTP comes. Before submitting, you see that there's a checkbox right below that particular login page, right? Where it says, I hereby give my personal data for newsletters, which is one purpose of the organization, account opening, which is the second purpose they are taking your data. Third could be for credit card. So at this moment I don't want to apply for a credit card, but the consent box still says, the statement says that I when I give you my personal data, you can reach out to me for credit cards, for sharing your newsletters, for promotional marketing, and as a bank I will also share your data with third party. So that is called blanket consent, it's called bundle consent. Before the enactment of DPDPA, it was considered a valid consent, but now that particular consent, where there is just one pre-ticked checkbox that was given to you as a data principal or as an individual, is no more a valid consent. You also go to banks and they take your signature on a paper. That is a physical consent. Now, that is also not a valid consent. So, what makes a valid consent under DPDPA is it should be specific to the purpose for which I am giving my data, which means if a bank is providing me four services by just mere taking my mobile number, then they should also give me four check boxes which states different purposes. So where I have an option to click on the mandatory purpose, which could be the account opening for which I went on the website, and second one could be a promotional purposes, which could be which could be a non-mandatory one. So I want to give my data for account opening, but nowhere I want to obtain a credit card for them, right? So as a data principal, I should have an option to say no to the non-mandatory purpose. So that will not be a blanket consent, that will be specific to the purpose. Then of course, when it comes to free, so it should not be like that I give you my consent and you will be giving me 500 off. If you would see some of the e-commerce website, if we take an example of Amazon or Myntra, sometimes when they take your consent they also have a condition attached to it that you tick on this checkbox and you will get extra 500 off, or or you give your more personal data, you add your date of birth, and we will be giving you more discount on your birthday. So most of the organizations are currently doing it. We are not saying that's not a valid purpose, that is a valid purpose, but I as a data principal should have a right to say yes or no to such purposes. It should not be a mandatory purpose where you have to take my data. Now, this is consent, how a consent should be obtained. Now, what is informed consent? The law says that, with every consent that you are taking from me, there should be a privacy notice attached to it. What should be there in the privacy notice? Which means when I click yes, first there should be an affirmative action. It should be not a pre-tick check boxes. I should have an option to say yes or no to that particular consent. Second is there should be a privacy notice served to me, which means you as a data fiduciary have to serve a privacy notice with every request of consent to the data principal, to the individual whose data you are collecting. Now, what makes a privacy notice a valid privacy notice? The first condition is it should have an itemized description of all the data that you will collect about me, which means that if you're taking my name, if you're taking my mobile number, my email address, PAN card, Aadhaar card, even if you're collecting my IP address, my digital footprint, I should have that particular notice which states all of these details. Second is it should have the retention period mentioned, which means how long you will be retaining my personal data. This law is very clear, right? Nowhere it talks about that you should retain this personal data forever. There should be some period attached to it, because if you keep that data forever without any particular purpose, there are more chances of breach. So if you are retaining that data post is use, ensure you obtain a fresh consent from the data principal, from the individual. The first one is the itemized description, then, of course, the retention period. For what purpose you're collecting my personal data, like we have discussed. For example, your university collects your personal data first for the educational purposes. Then they also collect your personal data to share with third party vendors who will be helping them, such as admin. They could also share your personal data with recruitment agencies to provide you job, to placement agencies. Then they might also share your personal data with other university, so they can reach out to you for further education, for masters or any other courses, right? So as a privacy notice, when I receive it, all of these information should be there. Apart from that, there should be an information of the data protection officer of that company. The law says a data fiduciary should have a data protection officer who will help them in exercising the rights request that they receive. A data protection officer will also oversee all the privacy compliances within the organization. They will also report to the senior management of the organization. Apart from that, DPO also responds to the right request. Apart from that, then there's another obligation which comes, that you have to conduct a data processing impact assessment. Now that is more of a practical way of doing an assessment for the organization. So within one organization there are multiple departments, right? The first one being marketing, then they also have sales department, they have operational department, legal, finance. All of these departments have different purposes of collecting personal data, and they all somewhat, whatever the personal data comes within the organization, they all are touching this personal data. Is going through their systems, is going through multiple employees, right? So they should also conduct a processing impact assessment, where they'll be able to assess what kind of activities they are doing, what is the data flow, how this data is entering to the organization, where they are storing it, what are the basic security measures that they have mentioned in the DPIA, that they are taking care of it, how they can transfer this personal data to external parties, whether they have a lawful means of transferring that personal data, how long they have been retaining this personal data, whether they have a retention policy in place, retention schedule in place. And the law says that as a significant data fiduciary, so there's another class of data fiduciary in the act which covers in section 10. One is a normal data fiduciary. For example, some university only have 5,000 students and they're only collecting students personal data for one purposes. But then comes your telecom providers like Airtel, where they have large amount of personal data. And then also comes your medical systems, right? Let's say your hospitals, your healthcare providers, banks. Some of the banks have large amount of personal data, and they also collect data which is more sensitive in nature. Now, here in DPDPA, every data comes under one purview, which is personal data. On the other hand, if you go and look at GDPR, GDPR defines three categories of personal data. First, being the personal data, where your name, mobile number, your IP address, your location, country name, nationality, your email address comes. Second, they also have a sensitive category personal data, which is more sensitive in nature. Now, how can one particular set of data be more sensitive in nature? Think of it like this example. So, if your financial data gets breached, the repercussions could be higher when it comes to your name and email address. So if a hacker just have your email address and mobile number, they might not able to harm you, in a certain manner. But on the other hand, they also have your financial details. Now they also have your medical details. So you could be a party to a medical scam, you could be a party to a financial scam, which happens in this country most of the times that we are looking at. You receive calls, then you share your OTP, and then all of a sudden you see that your bank account is empty. So that's why it is more sensitive in nature. So under GDPR, your financial data, your health data, anything which is more sensitive in nature eventually becomes the sensitive personal data. And then the third category of personal data is special category personal data, which is the criminal conviction data of any individual. But these three categories are defined in GDPR. In DPDPA, which all of this comes under one specific type of personal data, which they have mentioned as personal data under section 2 of the definitions, if you look at. Now, these are the certain obligations that you have as a data fiduciary. Then, what are your duties as a data principal, which means as an individual whose data these organizations are collecting, what duty do I have? The first duty that I have is whenever I share my personal data with any organization, I will have to ensure that data is accurate. Whenever I am raising any right, that right should not be a false claim. It should be raised within the limits of it. So these are two duties I have. And if I share inaccurate personal data with any of the organization, then I as an individual have to undergo certain penalties. These are the duties that you have as a data principal. Now you also have certain rights. The first right that you have is right to access, correct, and erasure of personal data, which means now as an individual, you can go to any organization and ask them to delete your personal data. You can also ask them that please provide me with a copy of my personal data that you hold. Second is you have a right to grievance redressal, which means you as an individual and as a data fiduciary, such organization have to provide you a platform where you can raise your grievances against that particular organization. Like, for example, if they are not responding to you when you're requesting for access of your personal data, then of course you also have right to rectification, which means you can go to any organization, look at their principal rights page, or you can also write to their data protection officer, where you can tell them that I have updated my mobile number, please update the same in your system, or I have updated my address in my Aadhaar card, here is a copy of my Aadhaar card, please update your records. Apart from this, you also have right to nominate, which means now you can nominate another person to exercise your right in case of disability, in case of death. Apart from this law focuses on collection of children's personal data, which means any organization who collects children's personal data and process it, anyone who is below the age of 18 is considered a child under this law, is considered minor. So as an organization, when you collect children's personal data, the first obligation is you cannot do targeted marketing on them, or you cannot do behavioral monitoring of that particular data. Then whenever you're collecting any children's personal data, there are some applications like schools have to collect children's personal data in order to provide them education. In that case, you have to obtain parental verifiable consent from the parents of that individual, of that minor. So they will have a parental consent workflow that they will define. They will have to amend their processes to ensure they are getting compliant with this law. Now, as a data processor that the data fiduciary is using to deliver these services, who is acting on a behalf of the data fiduciary, what you have to ensure. So under DPDPA, you don't have many obligation, but in case of a breach, in case of a data breach, you will have to ensure that you share the breach notification, the breach document, or how the breach happened with the data fiduciary, so they can report it to the Data Protection Board of India within 72 hours. You also have to follow reasonable security safeguards. Which could be a reasonable security safeguard, right? The first one being is, of course, you have to provide access control. Only need to know basis information you should be sharing. Once the purpose is fulfilled, you need to ensure you're deleting that particular personal data. So these are the obligations, duties that we have of data principals, data fiduciary, and data processors. Manita, can we move to slide next, or maybe pause that? Yeah, we have already covered this. Next one. We have covered this part as well. Okay, now here, what most of the organization are thinking about, they not in India but in most of the countries, whenever there's a new law introduced, there's a lot of traction. There are people who are against it and there are people who are for it. But when it comes to DPDPA, you will have to understand that DPDPA have penalties which can go as higher to 250 crores. So as an organization, you have to think, not just think about the cost of compliance, but also what happens if you don't comply with such legislation. So violations, per violation of this law, the penalties can go up to 50 crores, steep 250 crores. And these are somewhat similar to what we have in GDPR also. In GDPR, if there's a breach, the penalties can go up to 4% of the annual revenue, or 4 million. So these are some of the penalties that we have. Now, there's a very famous quote which says, if you think compliance is expensive, try non-compliance. So I think this mostly applicable to the DPDPA of India. Here we have in this case. How you can prevent any breach? You have to ensure about the privacy by design principle. You will also have to ensure that you are getting consent, proper consents from the data principals. You have a consent manager in place who can help you withdraw these consents, track. You have made proper evidence of such consents, of the data protection compliances that you are taking care of. You're conducting annual DPIAs. Whenever there's a right request coming to you from any individual, you're addressing those rights. So these are the basic obligations that you have to take care of, apart from the data minimization. Whereas an organization, you have to think of only collecting data which is necessary for that purpose, and do not collect unnecessary data. We can move on to the next slide. Next one. Now, let's talk about the practical aspect of this compliance and what is privacy by design. So, we have definitely covered the law part, the what and the why and how it is applicable. Now, let's also understand what are the basic principles of privacy by design, and how do you take everything that we just discussed and then you also turn it into a competitive advantage for the organization, and what makes your organization look more privacy compliant, makes your organization more trusted. Because every organization that you go to or where you share your personal data, they will have to comply with this law. Because any organization, they collect personal data in digital manner for any of the services. Even if someone says, I don't sell D2C directly, they still collects vendors personal data, they still have employees, they still go for a job opening. So it's not some kind of an optional law, it's more of a mandatory. Now the question that comes is, are you going to do it like it's a tax that you're paying, or are you going to think of it like an investment that you're making? So here we really need a mindset shift. And once that particular mindset shift comes, this law becomes easier for any organization to comply. Now, also, when we comes to compare design and default, what are these principles, and how these principles actually developed the GDPR and also now the DPDPA? Let me walk you through them very quickly, and they're quite understanding in nature. The first one being proactive, not reactive. So here it says that organization should not wait for a breach to think about privacy. think about it before you write the first line of any code. Whenever you are thinking of developing a system, think about it from the start. Before you onboard the first vendor, think about privacy. So let's take a real life example here. Apple, when they launched application tracking transparency in iOS 14.5, they didn't do it because regulators forced them
Ma'am,
to.
please on the camera.
I'm sorry, is it off now?
Yes, ma'am.
1 second, let me see again. Some issue. Hi, is it better? Can you see me now?
Yes, ma'am. Thank you, ma'am.
Thank you. So now think about Apple. When they introduced this particular tracking system, no regulator forced them to do it, right? They did it proactively, and it became one of their biggest marketing differentiators. They gained more trust from the users. Apart from that, now their billboards literally say, "Think about privacy, think Apple." What's privacy for you? That's an iPhone. And now that's what happens when you put a principle into action in reality. On the other hand, if you look at the other companies such as Meta, they have been collecting personal data like candies for a long time now. And if you also go and look at GDPR enforcement tracker, there are so many fines which are already put on these companies who are not thinking about privacy by design, who are not thinking about privacy proactively. So getting privacy compliant not only gives you a competitive advantage, it also gives your user a trust, that this company cares about our privacy, like Apple has been doing for most of the organization now. Then comes privacy as the default, which means we will, of course, understand this more in detail when we move to the next slides. But it's like you have to give an option to the user where they don't have to think about privacy, which means that your user don't have to do anything to protect themselves. Like they don't have to uh, install a particular application and then they look for how they can turn off the location setting or how they can turn off message setting. When you are developing any application or whenever you are also uh, proposing a vendor, at that moment only initially you have provided them with a default option of privacy. It is also where the individual who is coming on the website or who is using that particular application, they are not worried about how much personal data they're sharing to you. Then comes privacy by design, how you embed privacy within the design of any organization or any of the system that you are designing. So here you have to think that privacy isn't a feature that you think at the end of developing any system. You have to think about it from the start only. Whenever you're developing any AI model which will not collect any personal data, ensure that there is no way that any user can go to that AI platform or to that AI chatbot and submit their personal data. That would be a great example of privacy by design. In this, the risk mitigation is proactive. You have to anticipate the threats that will come. You have to address all of these issues in the architecture of that particular system, in the architecture of that particular website. Now privacy impact is assessed at the product and process design stage as well. Of course, systems is, we know how organizations develop applications, how they develop websites or user friendly dashboards. Then when it comes to processes, which means when anyone is designing a marketing campaign, they will have to think of privacy from the start point. If the law says that you cannot collect children's personal data and do behavioral monitoring on them, then your marketing campaign should not be targeting such children's to do behavioral marketing, to do personalized advertising on them. Then of course, when it comes to data protection, it covers the full life cycle. The privacy by design principle, it should be, think of it from the collection point of view. When you're processing that personal data, storage, sharing, when you're also deleting the personal data of individuals that you have collected, you will have to think about privacy by design. Privacy is also a core requirement. It's not a feature that you can add later. It should not be like what happens if I show them consent notices. If my users get consent fatigue, It should not be like that, because you have to design privacy within your system, within your processes, within the organization from the starting point of designing any process or any of the systems in place. Then comes privacy by default. Okay, here the more strictest privacy settings apply, the more your user will not have to think about having a violation of their privacy or breach of their personal data. Here you need to ensure that the data minimization principle is applicable, where you only collect data which is necessary for the purpose. There should be no optional fields pre-filled or pre-selected that as a user I have to have shared these personal data. Like you see in most of the application, when you install them, they already have access to your geolocation. They already have within the settings your camera access, your gallery access. So it should not be that case. And if you want to withdraw your access from the camera settings or from the location settings, you will have to go to that particular application, search for it. Then it becomes really difficult for you to disable such settings. So it should not be there when it comes to privacy by default. Now, consent is opt-in only. There should not be pre-ticked check boxes. There should be no assumed consent, for which for means, if I as a data principal I have given you my consent for marketing, then it should not mean that I also want have given you my consent to share my personal data with a third party who can now call me and process my personal data and sell me their services. It should not be like that. Then there should be purpose limitation in the system, which means you should only be collecting my personal data which is required to fulfill the particular purpose. Like for my for let's take an example. If as a recruitment consultant or if as a recruitment agency, at the interview stage I also ask for your PAN card or Aadhaar card, then that would be violation of purpose limitation as well, right? Because when I'm applying for a job, all you need is my resume, or you could need my educational certification, but in no way you would require my PAN card. So that should not be the case here. Then also the user must actively choose to share more. As a user, I should have an option to think about what I want to share, how I want to share it, and what I do not want to share. Sharing less is always the default, privacy by default example. Now, here are the examples how you can build privacy within the organization and how you can make privacy a competitive advantage for your organization. Can we move to the next slide? Thanks. Now, privacy as a competitive advantage. On Cisco's 2024 data privacy benchmark report, it was found out that 94% of the organization, they have mentioned that their customer will not buy from them if the data was not properly protected. In fact, when we do compliances, there are so many organizations who do business in Europe. They come to us and they say that, because I don't have the GDPR seal on my website and I don't have a valid privacy statement on my website, the European customer is just coming and not sharing their personal data, which means the leads are not generating. So it is affecting their business when they are not thinking about privacy as a design, or when they are not even thinking about privacy. So that's a revenue metric, you see, where these kind of principles, where not having a privacy compliance could make you a less secure organization in front of your customer, where your customer do not want to trust you because you don't have a proper privacy statement. You're not a GDPR or a DPDPA compliant organization. So when Vistara was getting merged with Air India, I'm not sure if you all must have seen that particular article or not. In the newspaper, they literally published a notice that we are now being merged with Air India, and all the users who wish to delete their data or who wants to know more about our privacy settings or how they can exercise their right, they can reach out to our data protection officer in this particular email address, or this is how they can reach out to us. So that is all about privacy, right? How they are engaging with their customer, how they are gaining their trust. So when you have systems in place which are privacy compliant, when you already have ISO 27701, when you have a compliance evidence for the DPDPA, it makes your organization more approachable. It makes your organization more transparent to the users. And when you provide transparency to your users, at the end your revenue will generate, because now as a user I have more trust on you. So now you might have seen that some people actually genuinely are more loyal to Apple. It's not because it's a status symbol, it's not just because they have good features, but because Apple thinks about privacy from the start. Like I've mentioned initially, their billboards are now all about privacy. Think privacy, think Apple. Now these are the organization that you want to build as a startup founder or as an entrepreneur. These are the organization where user can put their trust without thinking that my data later on can be used for tracking me, or it can be used later on for doing behavioral monitoring on me. So that is why we will have to ensure that we are using privacy as a competitive advantage. There are certain organizations who are very focused on privacy, who think about privacy from the starting point of view. Of course, your brand credibility, your user experience, customer loyalty, these are one part of it. But even in your investor and the kind of reports that MCA requires you to submit, there are literally four questions which only talks about privacy: whether there was a data breach happened, how you're securing your systems, how many individuals raise rights. So all of these things are there in place. Now, one of the examples of privacy by design and privacy as a competitive example advantage could be the cookie banners under GDPR. And increasingly now the DPDP also we have in picture, a compliant cookie banner should have reject all as prominent as accept all. So all of these things are there. Now if you look at most of the Indian organization, they just have accept option. That is not privacy by design, that is not privacy by default. That's privacy by inconvenience, which should not be there. I should, as a data principal, have an option, have a choice to think about privacy, to give you, to have an option to give you my personal data, to share my personal data with you. And finally, the global market access. When you are compliant with legislations like DPDPA, with legislations like GDPR, your organization automatically becomes more more visible in the global market, because these are the laws that global industry usually follows. You're well positioned in the global market. Now there are other laws also which are coming into picture, like Singapore's PDPA, Brazil's LGPD, and whatever comes next. So all of these laws put you in a better market position. It helps you in your market expansion without any rework. So these kind of principles that we have built our organization on, they actually protects you, and they also competitive advantage. Can we move to the next slide? Now, DPDPA in the global privacy landscape. India now joins, the group of 130 plus countries where they have a competitive, a comprehensive data protection legislation. Let's understand how DPDPA is different when we compare it to the global frameworks, and how it helps organization prepare for cross-border compliances. So, of course, the DPDPA scope is where any organization is providing uh, goods and services to Indian citizens. The European comes is the EU GDPR is where processing of personal data of EU residents by any controller or processor, and CCPA is a California privacy law where business collecting data of California residents, and there is, of course, it's not like it's applicable to all of the organization. There's a revenue threshold that they have to follow, and it's only applicable to those particular organization. Then consent model in DPDPA, it's opt-in. It's about free specific consent. It should be, the privacy notice should be presented in 22 languages, which we have in the third schedule of constitution. When it comes to GDPR, it also follows the opt-in approach along with the other five lawful grounds of processing they have, like legal obligation. They also have a contractual necessity, legitimate interest. California is basically based on the opt out approach. So, as a user, they have a right to opt out of sale and sharing. And, as a Californian organization, you will also have to ensure you have a proper opt-out link or opt-out option on your website where a user can directly opt out of sales and direct sales and direct sharing of personal data. Penalties in DPDPA, we understood it's 250 crore per violation or 50 crore per violation. Under GDPR, we have 4% of global annual revenue or 20 million, whichever is higher. Under CCPA, we have up to 7,500 per international violation. Then breach notice, whenever there is a data breach in DPDPA, you have to report it to the Data Protection Board of India and to the data principal within 72 hours. In GDPR, you have to first conduct a DPIA to assess whether it was a high risk or low risk data breach, and then you have to report the supervisory authority within 72 hours. Here, in CCPA, you have to report to the consumer without any unreasonable delay. Now, when it comes to having a data protection, it's not mandatory in DPDPA as of now. Only significant data fiduciary who collects large amount of personal data or who collects more sensitive nature of personal data, they have to have a DPO in place. Then in GDPR, every organization have to have a data protection officer. In CCPA, you don't have a DPO requirement. And the organization that treat DPDPA compliance as their first step toward global privacy maturity, not their last, they are the ones who will finally win the cross border business race. In DPDPA, under section 16, the law says you can do a cross border transfer only to the countries which are not blacklisted. Now, who are these blacklisted countries? This is something that the central government will notify, I think, once the law is fully operational. In GDPR, there are certain list of adequate countries where you can share personal data of European citizens, but then there are additional safeguards as well. Can we move to the next slide? We can move to the next one. So here I have prepared a case study for all of you, how we have done compliance for one of the largest NBFCs in India. And this was a large non-financial banking company. They had nationwide operations, millions of customers, extensive third-party partnership with direct selling agents, they call DSCs, fintech platforms, collection agencies, and they had many layers of third-party partners, which are also known as data processors. And when we started here, this is something that we actually, were able to assess that there was no third-party onboarding forms which are more privacy compliant. Now, there were no contracts in place which were protecting that data fiduciary in case of a breach from the processors and from the third parties. And uh, we also understood that the third party partners which they were using, they were getting access to customer data without any documented obligations on how to handle it. Then there was no employee awareness, because if you look at the GDPR enforcement tracker, you would see that the number of breaches that happened before the enactment of this law, they are mostly because of the employees, because employees are the party of these personal data. They use these data on a day-to-day basis, but at the end there's no awareness on how they should be using it, how they should be treating their customers personal data. And almost no one in the organization had any idea about this particular new legislation, what this is all about, what are the responsibility they have to follow, how they can make process changes. Apart from that, their website and application, there was no structured consent mechanism. Most of it was about blanket consent. There was no granular cookie controls. There was no clear privacy notice which was compliant to the DPDPA. And then there was no compliance with the data protection impact assessment requirements. And there was no formal way of managing data principal rights or grievance addresses. How, what they have to do whenever they receive any data principal rights, or whenever there's a grievance raised to these organizations. Now, this, when it comes to the scale of engagement, the law says that your privacy notice should be displayed on all of your public facing channel. So this organization, they had their website, they had mobile application, and then there were certain internal processes where they were getting data from third parties, and how they are also sharing these data with the third parties. Now, there were certain personal data policies which we framed for example, which covered the collection of personal data, processing, retention, deletion. There were certain retention schedules drafted. Then we also drafted 20 plus consent templates, and we also made sure that there's a full consent management framework provided to these organizations so they can manage and withdraw any consent request. Apart from that, there were certain principal rights disclosure forms, access forms that we have provided, grievance addressal workflows, the timeline, risk assessments, how these risk assessment also cover cybersecurity, data breach, vendor compliance. So this is something that we have proposed them, and they were ready to implement these things. Now, when you look at the scale of what we have, delivered here, where it gets real, because when you share all of these new changes to an organization and you ask them to make certain changes in their existing processes, of course initially they become reluctant. They don't want to do anything which will affect their processes. But what about the penalties? What about the legislation which is now in picture? So this was a full organizational transform that they had to go through. Apart from this, we also provided awareness training. We also provided certain assessments to their employees, so they can ensure that they are now aware about these legislative changes. Just like posh compliances, how you have to do every 6 month training. Here also we ensured that they give their employees an employee awareness session on the data protection policies, on the DPDPA Act annually. We can move to the next slide. Thank you. Now, how compliance was achieved here? Initially, we also set up a data protection office for them, where we established a fully operational data protection office. We defined certain roles, reporting lines, who the DPO will report to, escalation procedures, which were really aligned to the DPDPA framework. Now, processing activity mapping. Any department within the organization who collects personal data and use personal data, we call them processing activity. So then we identified and we also segregated certain departments based on the complex processing activities and less complex processing activities. We also drafted records of processing activity for them so they can map all the personal data they have, the data processors they have, third parties. Then we also provided organization wide training program. We provided them a thorough analysis on how they can enhance their data safeguards, how they can have encryption in place, they can have data masking, they should also have audit trails, and how their systems can be ready to handle such personal data. Then of course privacy notices, cookie notices, how a cookie banner should look on the website. We also help them develop SLAs for grievance redressal, escalation paths, templates on how they can respond to these data principal rights, DPIA, future proofing, how they can and their DPOs can run DPIAs annually. Once as a consultant, we exit their environment. And apart from that, we also developed certain breach response protocol for them, which were also based on the incident response plans that they shared with us. Because of course in this law, breach management becomes a major part of it. You have to report the data breach within 72 hours to the data protection board. So we ensured all of these SLAs are defined for them. We can move to the next slide. Now, what we have done for that particular organization, it actually made them not just compliant, but they became operationally stronger. When they started doing partner onboarding, it became faster because now the data protection clauses were standardized. Now their vendors don't just stall the processes, they ensure that they follow these safeguards they have in place. The risk posture was proactive. The customers could see it clear that how these privacy notices were developed when they open this application, how they are taking consent. So that trust became a signal for that particular organization. Then also their customers make could make better decisions every day because they understand what privacy means in their specific roles. And their vendor selection, of course, with the vendor onboarding forms, with the DPA, it is future proofed. Every new tool, every new integration gets DPA assessment before it's approved. Now they think about privacy by design whenever they run any new campaign. And not just the vendor's privacy landscape, because here whenever there's a breach or violation from a vendor's side, the vendor is not responsible. The penalty will come on the data fiduciary. So when they provided their vendors with these specific clauses, when they had vendor onboarding forms, their entire process became standardized. And that's what we mean when we say that privacy is a business enabler and not just a checkbox. It's more of an operating advantage. I think this is all from my side. Thank you so much. If you have any questions, I think we can take those now.
Thank you so much, ma'am, for such an enlightening session. This discussion has set a strong foundation for all of us. Now we're opening the floor for questions from the participants. Participants, kindly drop your questions in the chat. If you wish to speak, raise your hands and we'll call you one by one. And we will take as many questions as the time allows. Ma'am, we have one question in the chat box.
Yeah, I can see the first one is, how will you verify whether the person giving consent is competent or not? Now, there are measures for it. Like I have mentioned, there's a consent manager solution which will help these organizations verify whether that person is a minor or a major. There will be parental consent workflows. There's one option that they can identify the identity of that particular person via DigiLocker. So that is one of the options, but apart from that, there will be multiple criteria that the organization will introduce now to ensure that they are not collecting minors children's data. I think there's one more. So relief to data subject in case of a data breach. As of now, we don't have any compensation method to provide the data principals in this case. But let's hope that when this law evolves and there are certain amendments and there's certain provisions which are challenged, we do get some option to raise these compensation. But as of now, the law is silent on those aspects. I'm not able to see any other question.
Ma'am, may I ask a question?
Yes, please.
Ma'am, thank you, ma'am. Ma'am, what are your insights about the dark web, ma'am? Army uses dark web, and why the government should not ban it? Because for the humanity sake, and ma'am, for the sake of privacy also, the DPDP Act give provisions, any provisions to ban it, or like the restrict the use for common people.
So as of now, the law is silent about it. There is no specific, obligation that how organization should not be using it or who should not be using it. So there, it's unclear about it.
Yes, ma'am. But
Ma'am,
why governments are silent or law is silent about that much sensitive topic? Because the dark web is the main core and spinal cord of the cyber crime, I think.
Yes, so see, there are still some people who uses dark web. I mean, of course, it is being said that most of the information that you share online is already available on the dark web. There are certain debates going on about it, but as of now, DPDP is not covering that particular aspect. Then, of course, you also have IT Act in picture, where they restrict organization to use any such website or collect data from any such websites. But under DPDP, it's more focused on the personal data aspect of it. In later stages, when the government comes up with the tracking rules where there will be AI regulation, I think then we will have more stringent measures for it.
Ma'am, I have a question.
Yes.
Ma'am, I had applied for KSET, NEET, CLAT, but I never appeared for it. And now I'm getting emails saying that congratulations, and we will be giving you admissions. And I've got more than 140 plus different colleges and universities. They're directly giving me the admission without me actually appearing for those exams. And I've been continuously flooded right from my parents' number. They're also getting WhatsApp, they're getting calls and SMS. My number also. I mean, everything is just out over there. How and what action can I take, ma'am?
Okay. So as of now, what you can do is you can go to all of these websites where you're receiving these forms from, and you can look at their privacy notice if they have in place, and there would be a data protection officer's number or their email address. You can try and reach out to them. And the second thing that you can do is, of course, the first thing being where you can reach out these organizations and tell them that you do not wish to let them process your personal data, and ask them to stop processing and stop sharing these emails with you, because you never consented to being their customer or anything like that. Second is when this law is fully operational. So since November 2025, we still organizations still have 18 months in total to get compliant with this law. The data protection board will be functional by then. One, if you don't receive any response from such organizations or from their DPOs, then after exhausting all of your measures, you can complain to the Data Protection Board of India specific to this organization that you have been reaching out to them and asking them to stop processing their personal data, but it's not happening. That
Thank you.
option. Yes,
Thank you
and you
both.
can also go for DND. You can see if they have any terms and condition, and there is a DND to it.
Thank you. Thank you so much, ma'am.
Ma'am, there is a question in chat box from group. Ma'am, my niece was born in Loknayak Hospital 3 years ago, and after 2 days, I received a message on WhatsApp for birth certificate. It looked official, and I believing it to be true. Paid 200 rupees on QR code shared by it. Although the amount was very small, but the issue was big. The real amount for the certificate by MCD was 25 rupees. But when I found out that it was scam, I tried to file complaint on cyber police. When I called them, instead of registering my complaint, he said I should be aware of the next time, from the next time. I called them so that no one else be scammed, and I got the reality of the system. In such big hospital, data is leaked. Who will be the accountable for it?
Okay. So I'm so sorry that happened. That's why we have the DPDPA in picture, because now if such things happen, the organization will be accountable, will be held accountable. If there's a data breach, there's a penalty which can go up to 250 crores. So then organization will have to be more proactive when it comes to privacy, and they will have to think about these things in advance.
Good
Ma'am,
evening, ma'am.
another one from Akshay. How to harmonize IT Act 2000 and DPDP Act, and which will be the prioritized in case of conflict?
Okay, so DPDP will not override any of the legislation, be it IT Act, be it RBI. Then, when it comes to how to harmonize, Section 43A of the IT Act along with the SPDI rules will now be repealed with the DPDPA coming into picture. So, whatever personal data obligations organization had to follow under Section 43A and SPDI rules, they will now move to DPDP Act. So this is how organizations are usually taking care of these two laws. But still, there are certain measures in the IT Act which they have to follow. But when it comes to personal data compliance, they will now totally be dependent on the DPDPA compliances. So can we just take two more questions?
Good evening, ma'am. This is Sirisha. I have one doubt whether we can apply DPDP Act to my case scenario. One document like I have got from like in 1994 from secondary education, where my name was wrongly typed. So now can I ask for update of my data under DPDP Act?
Yes, you can, but I think it's more about the it's an educational document which you might have received government authorities. So even before the DPDP, you still have an option to go and correct it. I think you have to submit certain affidavits. So I think that can be done. You can reach out to that particular authority, local authorities, and they will help you in this. So can we end the
Yes,
session
ma'am.
now?
With this enlightening Cyber Sundays episode 27 session, we now come to the end of our program. We sincerely hope that today's session proved highly informative, enriching, and thought provoking for everyone present. On behalf of Naksh Foundation and Project Cyber Shield, we extend our deepest gratitude to Ms. Akanksha Bhatt for conducting such an insightful session. Your deep expertise, practical guidance, and rich industry experience have greatly enhanced our understanding of privacy as a strategic business enabler. Before we conclude, we invite you all to join the Volunteer for Your Community campaign 2026 by Project Cyber Shield to become a change maker and conduct cyber awareness sessions in your community. To register, simply scan the QR code which is displayed on your screen. Moving on, we kindly request all the participants to complete the post-assessment form by scanning the QR code displayed on your screen. Please note that the certificates will be issued only upon successful submission of the feedback form. And if there is any query regarding the session or certificate, you can email at event@naksh.org. Thank you all for being part of this learning journey. We look forward to welcoming you again in our upcoming sessions. Until then, stay informed, stay vigilant, stay secure, and continue contributing towards a safer and more resilient digital world. Thank you, everyone. Goodbye, take care, and have a wonderful day ahead.
Thank you, everyone. Thanks, Manita.
Thank you, ma'am. Participants, the post-assessment link is also in the chat box. So if you're not able to scan the QR code, please access the form link from the chat box. The session will end at sharply 8:15 p.m. So this is a gentle reminder to all the participants to please fill out the feedback form and the post-assessment form to get the certificate.